So good afternoon. I'm Cecilia Rouse. I'm the Dean of the Woodrow Wilson School, and I'm here to welcome you to our two-day conference, Civil Liberties in Times of War. We're thrilled to host this event in partnership with one of the school's centers, the Law and Public Affairs program, the home of Princeton's archives, Mudd Library, and of course, the ACLU itself. We're proud of the connections the Wilson School has with the ACLU. Its executive director, Anthony Romero, is from the great class of 1987. And one of its attorneys, Nusrat Chowdhury, is an MPA alum from the year of 2006. And then one of our own faculty members, Stan Katz, has family connections through his wife to the ACLU, and I'm sure the list is much longer. The origins of this conference began with a meeting called by Dan Link, Princeton University's archivist and curator of public policy papers, to brainstorm about how we might highlight the fact that the ACLU archive is here at Princeton. Given all of the policy implications of the cases the ACLU has argued and won, over time, we were thrilled to partner in this event. Because we're a policy school, we wanted to explore ways that the legal and historical record can inform policy going forward. While the ACLU has covered a vast number of issues in its almost century-long history, we decided to focus on areas where security and civil liberties collide. This seemed to make sense today, given the policy debates occurring in state houses in Washington and abroad. The result is even better than we'd hoped. Today and tomorrow, you will hear from some of the best legal minds in the country who are working on civil liberties issues. Today's talk takes us back to the future before we spend tomorrow looking back to the past. Today's two speakers will examine how we should think about threats to civil liberties in light of new technologies that seem to pop up almost daily. Edward Felten is the Robert E. Kahn Professor of Computer Science and Public Affairs at the Wilson School and director of the school's Center for Information Technology Policy. Ed was previously the chief technologist for the U.S. Federal Trade Commission, and he's often cited in the media as an expert in security and privacy issues. His research interests include computer security and privacy and public policy issues related to information technology. Jeffrey Rosen is president and CEO of the National Constitution Center, a nonprofit and nonpartisan institution in Philadelphia devoted to the Constitution. He's a professor at the George Washington University Law School and the legal affairs editor of The New Republic. He's also a non-resident senior fellow at the Brookings Institution, where he explores issues involving the future of technology and the Constitution. Jeff is a frequent contributor to the New York Times Magazine, The Atlantic Monthly, NPR, and The New Yorker. The Chicago Tribune named him as one of the 10 best magazine journalists in America, and a reviewer for the Los Angeles Times called him, quote, the nation's most widely read and influential legal commentator, unquote. So that's sort of great, but I have to add, it's great for his mom, but he was also my classmate in college. Yeah, he's that young. So welcome to Princeton and the Woodrow Wilson School. We look forward to these exciting 2 days. Please join me in welcoming Ed Felten and Jeff Rosen.
Back at Princeton, we had such a great conversation here just last year about the future of technology and civil liberties, and what an auspicious occasion to resume that conversation here on the great anniversary of the ACLU. It's so wonderful that you're commemorating the ties between Princeton and the ACLU, and I'm thrilled to be here with my old friend, Ed Felten. So we thought this would be most interesting as a kind of Charlie Rose-style conversation between the two of us, with each of us being Charlie Rose to the other. We'll see how that works. And I thought I would just frame things by noting the big cases that are about to come before the Supreme Court involving technology and civil liberties. Ed will give us some of the technological background about exactly what's going on in the surveillance world. Then we'll go back and forth about the state of the law and technology, and then open it up for your questions. So it's possible that this year, or more likely next, the Supreme Court may decide what could be one of the most important civil liberties cases of the decade, namely, is the collection of cell phone and telephone metadata without a warrant consistent with the Fourth Amendment. The Fourth Amendment says that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And the question of how it applies in an electronic age is one that the court has been deeply engaged with in recent years. In fact, just last June, the court unanimously held that the warrantless inspection of the content of a cell phone on arrest violates the Fourth Amendment. This was a landmark, and to me, as a civil libertarian, inspiring decision. All 9 justices, led by Chief Justice John Roberts, rejected the government's claim that on arrest, the police have traditionally been able to search the person and seize and open any container found on the person. The government cited a famous case saying, if you find a cigarette package on someone, on an arrestee, you can open it up to see if it contains weapons. But Chief Justice John Roberts said, joined by all 8 of his colleagues, a cell phone is not like a cigarette pack. It contains our entire lives, the records of the people we associate with, our movements, our thoughts, our most intimate hopes and fears. Roberts went on in an inspiring passage to cite James Otis's denunciation of the writs of assistance, where James Otis said that the general warrants, which empowered the King of England to break into the homes of suspected violators of the hated tax laws and identify the culprits, were contrary to English common law. And Roberts quoted John Adams on behalf of the proposition that after Otis denounced the writs of assistance, at that moment, the child independence was born. And how exciting it was to see all 9 justices of different persuasions agree that warrantless searches of electronic data that reveal a great deal about us is just like the general warrants that sparked the American Revolution and is presumptively unconstitutional. But that important cell phone decision does not answer the question that we're going to be talking about today, namely, does the warrantless collection of cell phone metadata violate the Fourth Amendment? I can talk more about the legal differences between the 2 cases in a moment, but just the most obvious one is that metadata has a different legal status than the content of electronic data. The courts have held that the records of the telephone numbers we call doesn't have the same constitutional protection as the actual content of our emails and phone conversations and even geolocational data. So it's possible that the court might say that we have no expectation of privacy in our metadata and therefore it's fine to surveil it. But I'm getting ahead of myself there. I've introduced the topic. Ed, you know more than anyone else in this country about what is exactly going on about the collection of metadata, how the government is collecting it, what it's doing with it, what sort of suspicion it's then creating to dig down deeper. So tell us how, let's start with the domestic metadata collection program is currently operating.
Okay, so first, I think it makes sense to talk about what metadata is with respect to phone calls. And essentially what it is for each call that's made, it's a record of what the calling number was, what the called number was, and how long they talked, how long the call lasted. So that's phone metadata. And what has been happening for quite a few years now is that the government has been going to the major, or at least many of the major phone carriers, and using court orders issued by the Foreign Intelligence Surveillance Court to get essentially all of the phone metadata from the users of those companies' phone services. So if you are a customer of one of the phone services that's subject to one of these orders, then information about every one of your calls is being turned over to the government pursuant to these orders. And the companies are delivering the data, updating the data every day. The government has gotten a series of orders to these companies, which they keep renewing. And so this has been going on for a long time. This data all ends up, the metadata all ends up in a large database or set of databases that are within the intelligence community. And there are a couple of current legal cases, which I assume we'll talk about later, about the status of, the legal status of this activity, asking both, is it constitutional, and also is it authorized by statute? So what happens to this data once it's collected? Well, we know some things from the court papers that have been released, sometimes in redacted form. For a technologist like myself, it's, many of the redactions are frustrating because they make it difficult to understand some of the key questions that let us understand the implications of the analysis that's being done. But we do know some things. We know, for example, that, the government is doing a form of analysis that they call contact chaining on this data. And what that means essentially is to start with a particular starting point, you can call a seed if you will, which for some reason, a number which they have some reason to believe may be associated with terrorism or foreign espionage or something like that. And then finding all of the other numbers with whom that seed number talked. That's a single hop from the seed number in the terminology. And then for each of those, finding the numbers with whom they talked. That's the second hop, so that's 2 hops. And then at some times, they have gone out to a third hop. Although that's a practice which they've recently stopped. And so that then, you can imagine a sort of expanding circle around the seed number, which, and to some intelligence or law enforcement analyst, the result of that search gets delivered. And then, if we really dig into the procedural and legal nitty-gritty, what we find is that a number that is the result of one of those searches at the, say, the second hop, then moves to a different legal status, which, after which there are probably fewer controls on its use. Okay, so that's one kind of use of this data, and in addition, there's a certain amount of manual access and also other types of analysis. But one of the key questions here is, what does metadata, phone metadata, actually reveal about the individuals? There is, as Jeff said, there's a longstanding legal principle that information about the call, such as metadata, has a lower level of legal protection than the content of the call. So the government would not be able, with the same authority, to be able to listen in or get the audio content of a call. They would need a stronger legal finding to get that. But they are able to get the metadata. So what does the metadata reveal? And I've written about this at some length. There are a bunch of ways in which metadata may be more revealing than you would expect. Certain phone numbers, for example, are revealing just in themselves. If somebody calls the suicide hotline at 1:15 a.m., they talk for 45 minutes, you can be pretty sure what the call is about, and it tells you something sensitive about that person's mental or emotional state. There are various whistleblower hotlines, other kinds of services. Certain kinds of medical offices, for example, if you exchange a series of calls with the office of a certain kind of medical specialist, that indicates something likely about your health status or the health status of someone in your family. So quite often, even individual calls or back and forth patterns of calls between a pair of numbers will reveal something sensitive about the individual. What's even more revealing is if you then look at the patterns of a person's call. If person A and person B are people who might be romantically involved with each other, and you find that they often call each other late at night, maybe that tells you something. Information about what someone is traveling, information about who their friends and family members are, information about their political associations, all can be revealed by patterns of their calls over time. In some of my writing about this, I talk about a hypothetical of a young woman who gets a call from her gynecologist's office and then calls her mother, and they talk for a long time. Then she calls a young man who she often calls late at night, and they talk for a long time. But he never calls her back after that. She then calls a family planning clinic that offers abortions. And they return calls, and there's a back and forth series of calls. You can fill in the story, right? There's a lot that's sensitive in that story, but it's a story that's based entirely on metadata. One step even beyond this is what happens when you start to analyze metadata across a population, when you start to look at patterns of how different people, for example, students, have different patterns than other people. Unemployed people have different patterns of calling than people who are employed. And so if you have a large database of information about the population, as well as information about whether some of those people are employed or not, married or not, terminally ill or not, or all kinds of other statuses like this, you can use machine learning to build a predictive model that looks at a person's phone call pattern and makes inferences with some degree of confidence you can estimate about that person's status, about their life situation. And there's a big literature on this. And so we know that metadata, especially in bulk and when analyzed with modern data analysis methods, can be exceptionally revealing about individuals and about the population. One of the things that's, I think, unfortunate about the current situation is that we have courts that are trying to reason about this situation using legal precedents that date back to a time when you're talking about a single phone company employee clipping some wires to a single line in a central office. It's not at all clear, as a technical matter and perhaps as a legal matter, that it makes sense to just directly apply those precedents from old-style surveillance or data collection or analysis to the current state of the world where you're talking about such broad collection. And that kind of gets us, I think, to talking about the current cases which are working their way through the court system, and maybe you can talk about sort of where we are, what are the legal issues currently on the table about metadata?
Wonderful, that's great. And you see from Ed's superb description that it is in the details, and the constitutional analysis turns very much on how much about us is actually revealed. So you need to understand the technology in order to make a legal judgment. So let me try just to describe as neutrally as possible the best arguments on both sides of the constitutional case, and then we'll talk some more, and we'll talk among each other, and maybe we can even have a vote at the end. I should say, one of the great pleasures of my superb job at the National Constitution Center, a national treasure, which is constitutional heaven, and which I hope all of you will visit if you haven't yet, is that I get to moderate all of these great debates about constitutional issues. And every day and every week, both at the center and online in our superb podcasts, we are summoning the best minds in the country on both sides of all of these constitutional issues so that people can make up their own minds. And on October 7th, we're having an incredible debate with our friends at Intelligence Squared, the leading intellectual debate partner in the country, on precisely this question that Ed and I are talking about now. Does mass warrantless surveillance violate the Fourth Amendment? So I view this as a dress rehearsal for what I'm sure is going to be a dynamo debate between John Yoo and Stuart Baker arguing against in favor of the constitutionality of metadata. And I think, Anthony, who is the lawyer who's arguing the Clapper case? Is it? He will be there, and as will Elizabeth Wydra from the Constitutional Accountability Center, so it'll be a great debate. All right, so, but now I'm the head of the nonpartisan National Constitution Center, the only institution in America, as Cece said, chartered by Congress to disseminate information about the US Constitution on a nonpartisan basis. There's sometimes when you do want cell phones to be seized unconstitutionally, but not always our fault. What are the arguments on both sides? So a bunch of courts have upheld the warrantless collection of metadata, most notably the Foreign Intelligence Surveillance Court. That is not a full Article 3 court, but a court that meets in secret without access to arguments on both sides. And in a series of decisions over the past year or so, the FISA court has upheld the metadata collection both under the USA Patriot Act and under the Constitution. The constitutional argument is not very complicated. The claim is essentially, when I make a telephone call, I voluntarily surrender the metadata to the telephone company, which is a third party. There's a case called the Robinson case from the 1970s, where the court held that when you turn, Smith versus Robinson, when you turn over, bless you, information to a third party, you abandon expectation of privacy in it. Courts have held from that we have no expectation of privacy in the local phone numbers we call. And the claim here is that because I don't have an expectation of privacy in a single phone number I call, there is no additional violation if the government collects all telephone numbers. That basically, the collection of millions of telephone numbers has the same constitutional status as the collection of a single number. Neither is constitutionally protected. There was also a statutory argument that Section 215 of the USA Patriot Act, which authorizes the government to seize any data that's relevant to an authorized investigation, justifies the mass collection of metadata because the data might be relevant to future investigations, plural, the FISA court held. Therefore, the government may, under Section 215 of the Patriot Act, seize it. Here are the arguments on the other side. As a constitutional matter, some courts, including a particularly rousing opinion by Judge Richard Leon in DC, in the Washington, DC US District Court, said the collection of a single telephone number is nothing like the collection of hundreds of millions of telephone numbers. The collection of the millions of telephone numbers can reveal so much more about us, the people we associate with, the abortion clinics we visit. That wasn't an example he gave, but just in the spirit of Ed's notion that we can learn an awful lot about people from their calls in the aggregate, so said Judge Leon, we do have an expectation of privacy in the whole of our metadata. Judge Leon was also focused on the hops, which sounds like a delicious craft beer, but actually is a terrible threat to civil liberties. He said, you know, if I call, if the targeted person calls Domino's Pizza, then every other number that calls into Domino's might be vulnerable on the second hop, and that could lead to, what was the number? How many numbers being possibly
Well, it depends
examined?
how you do the calculation, but at 2 hops, it's anywhere, I think, from 0.1% of the US population within 2 hops of you or I to more, depending on how you do it. If you include the Domino's Pizzas of the world or United Airlines customer service or the other numbers that get called by a lot of people, then it might be even more. At 3 hops, it might be 1/4 of the US population within 3 hops of you or I.
So there were some gasps there. 3 hops did catch Congress's attention, and as you said, it's been scaled back, so it's now two hops?
It's been scaled back to 2 hops, and the reason I think is pretty clear, that any analysis that starts with someone who maybe you have reason to believe is affiliated with terrorism, but then goes out to draw in a circle which is 10%, 20% of the US population, that's not actually useful if you want to catch bad guys. 2 hops is more than enough.
It sounds
Even
like
leaving aside the constitutional issue.
Sounds like Justice Holmes, one generation of hops is enough. Yeah, it's exactly. So the question of whether it's necessary is also relevant to the constitutional analysis. Does the thing work? The president's own Civil Liberties Review Board, a bipartisan board which included Jeffrey Stone and Cass Sunstein and others, concluded that the metadata collection program itself had not stopped a single terrorist attack, that it was not useful and not effective. It contrasted that conclusion with the inspection of metadata of non-US citizens abroad collected under a different statutory provision, 702, which the commission said was useful, and therefore there may be a different legal status for the 2 programs, and we should talk about the non-citizen collection in a moment. Judge Richard Leon, therefore, said, ladies and gentlemen, please turn off those hated cell phones. Judge Richard Leon also said, although that's kind of jazzy, you know, he said, the second half, excellent. Very good. Leon basically embraced an analysis similar to the one that Justice Roberts embraced in the Fisher, in the Riley cell phone case decided last June. If collection of data can reveal a whole lot about us, we do have an expectation of privacy in it, and indiscriminate collection is like general warrants. So you could say that there's a decent chance that post-Riley case, the Supreme Court and other courts will say, even though metadata has traditionally had this different status, it should be subject to constitutional restrictions. Nevertheless, that would require re-examining or overturning cases like that 1970s Robinson case, which said that there's no expectation of privacy in metadata, or especially no expectation of privacy in data surrendered to third parties, which would be a big doctrinal move. There is also the statutory question. Critics of the FISA court decision have noted that Section 215 of the Patriot Act says that you can seize data relevant to an authorized investigation. The government, by contrast, is saying it may seize data that might be relevant to future investigations, plural. You're shaking your head, Your Honor. You're not persuaded by that argument. And the addition of the S, the fact that it's prospective and that it's plural, is arguably different than the intent of the framers of the Patriot Act. And indeed, the framers of the Patriot Act, including Representative Sensenbrenner, Republican, and Senator Pat Leahy, Democrat, who didn't sponsor the Patriot Act but opposed it, have proposed something called the USA Freedom Act, which would end the collection of metadata. So the statutory and constitutional questions may be affected by that legislative determinations. I guess the one other big case to put on the table is the Jones GPS surveillance case, a really fascinating case from just a few years ago. The question there was, can the cops physically affix a GPS device to the bottom of your car and track your movements 24/7 for a month? The Obama administration argued, we have no expectation of privacy in public because we voluntarily emit the images that may be captured by third parties, and because the cops are allowed to follow us for 100 miles, said the administration, we assume the risk that we're being recorded 24/7 for a month. And the Supreme Court, again, unanimously rejected that decision. And I have to say, as now in the nonpartisan constitutional biz, I just love these 9-0 decisions where all the justices are united in the importance of electronic privacy. But the justices did divide on important grounds. 5 of them, led by Justice Scalia, emphasized the physical trespass involved in affixing a GPS device to the bottom of a car and also walking onto the suspect's driveway. 4 justices, led by Samuel Alito, said it makes no sense to focus on physical trespass because the government could have collected the same information not by affixing a GPS device, but by subpoenaing the cell phone records held by Verizon or AT&T, which collects all of our geolocational records. And if you're going to require a physical trespass before you prohibit mass data collection, there'll be no privacy protection. There was a wonderful exchange between Justice Antonin Scalia and Samuel Alito on this score. Scalia said, we should ask what the framers thought. And Alito said, Alito also chuckled. He said, well, you know, they didn't think about GPS collection because there were no cell phones in those days. And Scalia said, no, but there was an analogy. You can imagine a constable spirited under a carriage and eavesdropping on the conversation, and that would be the same thing. And Alito said, well, since it would take 1,000 constables to get the amount of information that a single GPS device could collect, they would have to be very small constables or a very large carriage. So Alito is not an originalist in this matter, and he wrote quite an, talking about Princeton civil libertarian ACLU connections, Justice Alito, whatever class he was, I know you guys keep track here, that's 72, okay, there we go. And I gather he wrote his senior thesis on privacy and threats to electronic privacy in an age of surveillance. So Justice Alito has proved to be a great defender of privacy in this and other cases. I know there are others where he has been on the other side. You're shaking your head, but basically he's really been very thoughtful on these cases. And in this concurrence, he was quite visionary in refusing a kind of wooden property-based protection for privacy and saying the real question is how much about us these mass searches can reveal. And once again, he noted too, it can reveal all of our movements, our political associations, our friends, and intimate thoughts and hopes and fears. So many of the justices do seem to get it. And if they go with that analysis, the metadata collection might be struck down. Final note, Justice Sonia Sotomayor, in her concurrence in that Jones case, said, we need to re-examine this whole notion that when I turn over data to a third party, I abandon all expectation of privacy in it. Because in an age when all of our movements and thoughts and communications are electronically collected and stored in third-party databases in the digital cloud, the third-party doctrine means that none of that data is protected, and we have far less protection in the age of cyberspace than we did at the time of the framing. So perhaps this cell phone metadata case will be the occasion for the court to re-examine the third-party doctrine, and that Robinson case, that would be a huge deal, but it would be a big leap, so I'm not taking on any bets. So Ed, delve in even deeper on the technology, given the fact that we're now down to two hops, not three, and the fact that the Riley case is now on the books? How would you analyze the arguments on both sides of this metadata case?
Well, I mean, I think you have to, or at least my approach starts with trying to understand the implications of certain data being collected and then analyzed. And intuitions from previous generations of technology often don't work. You know, you don't hear ones that are as distant as 1,000 constables under a carriage. But nonetheless, even going back to the technology of the 1970s and 80s, things are very different now. And you have to take that into account. For example, when I was in college, long-distance phone calls were expensive. And when you made a call, you had a few precious minutes to communicate. Yesterday, I was talking to a Princeton student who was telling me that her boyfriend lives in another country, and they will often in the evening, while they're going about their business or studying, just leave a high-def video connection open for a few hours so they can feel that they're spending time together, right? So a multi-hour high-def video call is now free, whereas just, I'll claim it's still just one generation ago when I was in college, that even a voice call was something rare and precious. And those sorts of distinctions make a big difference. Really, three sorts of things have changed over the last generation. That there's now so much more information that is recorded and recordable. Second, that the cost of collecting and storing information is drastically lower than it was in a previous generation. And we see these things coming up in, and third, the methods for analyzing this data and extracting actionable or apparently actionable information from them are drastically more powerful than they were before. You see things like facial recognition, automated transcription of voice conversations, automated content analysis and pattern matching, social network analysis, et cetera, et cetera. And these things come up over and over. These technological changes really drive what's happening. So for example, the discussion about geolocation information from cell phones, right? The idea that every one of us carries around with us, or most of us carry around with us all the time, a device that is almost continuously reporting your location to a central database. That would have been unimaginable a generation ago, and yet that's the normal state of life for many of us. That's information that simply wasn't available to a would-be surveillance agent in an era when you needed a constable or you needed to put some expensive, fragile GPS pinging device on the underside of someone's car. Second, the ability to collect and keep information so cheaply. We see that coming up with the metadata, with the government wanting to collect information, not because they need it for an investigation that's going on right now, but because it might be useful later. And because it's so easy to collect this information and so cheap to keep it for a long time, this attitude, we'll just collect it all, and then we'll look back and see, in case we need it later, is something that we see broadly across government and in the commercial world. And that really changes the relationship between surveillance and surveillors and the population. We've seen stories about the US government in an overseas country recording essentially all phone calls in that country in case they want to go back and listen to them later. So you can get either a warrant or some kind of search, not only in the present and the future, but actually applying to the past. And that means that all the people who are subject to that are leaving a record wherever they go. And so our exposure to misdirected or malicious misuse of the data is much greater. And then the third piece, the analysis, really gets to the issues about metadata. Right? One of the reasons why revealing metadata is potentially more sensitive is because we know that there are advanced analysis methods that can be used to get information, to get apparently actionable information out of that, or information that might at least lead the government to act in some way, perhaps mistakenly. And so I think you really need to dig into this and ask, what are the implications of collecting this information? Outside this, and that of course applies to specific legal language. You talk about Section 215, for example, of the Patriot Act, and there being a standard of relevance for an investigation. You can ask, what are the different ways in which certain information might be used, and talk about scenarios, how it is useful for an investigation. And then you get the ability to separate what's really necessary from what's not. And with respect to collection, I think the fact that we're seeing a move to a collect it all and figure out its value later approach means that we have to approach these problems a little bit differently. For example, there is an argument that's made by government lawyers in some of these cases, in the metadata cases, for example, that it's okay to let them collect all of this data because there are controls on the usage afterward. And then you get into technical questions about, well, how well can you really corral the use of this data after the fact? To what extent is it possible or realistic to encode in the technology, in the software code, limitations on the use? To what extent can you build technologies that prevent uses, let's say, without some sort of showing of probable cause or a connection to an investigation? And I think if you look at those questions realistically, about how technologies can realistically be built and operated, and if you look at the history of technologies of this sort operating within government or within companies, what you see is that the controls on use are not as bulletproof as their advocates would like you to believe. That we see abuses, we see failures, we see misdesigns. We see them with the metadata that the government has collected. If you look back into some of the declassified or partially declassified past decisions by the Foreign Intelligence Surveillance Court, you see evidence of problems with the operations of these programs and the technical and procedural controls that were supposed to be in place not being followed reliably. Sometimes because someone was cutting corners, somebody wanted to spy on their ex-spouse, and those people end up usually getting fired, but nonetheless, the violation occurred. And you also see technical failures where the left hand of the technology implementers isn't in communication with the right hand of the general counsel's office. And so you see technologies in place that the general counsel's office may believe are enforcing some limitation, legally driven limitation on use, when in fact that limitation is not being enforced. And you see in some instances FISA court judges getting quite angry, frankly, with intelligence agencies about these violations and about how long it took to notice them and report them. And this doesn't necessarily reflect bad faith on the part of the intelligence agencies. It just reflects the reality of complex technology systems operated by actual people. That all kinds of things happen. And so there's a very real sense in which a large data set collected and held for a long time is like an underground oil tank, that you can do what you can to monitor. You can make a double-walled, triple-walled tank. You can do many things to try to prevent an accident, but nonetheless, an accident can happen, and the only way to know that you're not going to put oil into the water table is to not have a tank in the first place.
What's so interesting about listening to Ed's elucidation of how this stuff works is you see how dependent the constitutional analysis is on it. But that may not bode well for a Supreme Court victory for privacy rights. The cell phone case was an easy technology to understand. Can the cops look in a cell phone and dig deep into the content? All the justices could get that. But as Ed describes it, here we have questions both about how much potentially could be revealed by the metadata, which is vivid but takes some technical understanding of what the various hops are, and also the danger of abuse. So you might say, as the FISA court did, that you simply collect the metadata and no actual content is examined unless there's some individualized suspicion with oversight and authorization by an NSA official. By the way, that was a requirement that was added by President Obama after the criticism of the initial program, which had no such requirement. But nevertheless, you could imagine a judge saying, no examination, no foul. There's a search that takes place if the data is collected but not inspected, and therefore it's not protected. The other thing is that this is national security, not ordinary criminal law enforcement, and that does seem to make a difference. This is a conference on civil liberties in a time of war, and we know the rich history of the court's deference to executive claims of safety that later turn out to be overhyped, ranging from the Korematsu decision upholding the Japanese internment all the way up. There does seem to be a pattern that when executive surveillance is supported by Congress, the Supreme Court is more likely to be deferential to it than in cases of executive unilateralism. So the Guantanamo cases, the Bush administration lost when it asserted its power to act on its own, but once Congress endorsed the military tribunals, the court endorsed them too. So here, the opposition of the authors of the Patriot Act might be salient for the court. The fact that Representative Sensenbrenner himself is saying, that's not what I intended. It is true, though, that judges can be technologically savvy, and Judge Richard Leon, a Bush appointee, cited both the dangers of intrusion by the 3 hops and also the insecurity of the data and the fact that it was like a ticking time bomb and could later be examined. What I want, so predicting is not so interesting, but why don't we both try to state the argument against surveillance as convincingly as possible and see if the audience buys it. Because it's not so obvious and will require a creative constitutional act of translation no less bold than that made by my hero, Justice Louis Brandeis. So whenever I have a hard question involving technology and privacy, Ed knows I ask a simple question, WWBD, what would Brandeis do? I think, Anthony, was Brandeis a friend of the ACLU? Was he affiliated with, I think he was affiliated, I'm not sure he was directly on the board. Not on the board, but certainly a friend of and supporter of its efforts. And the greatest case for constitutional translation in the 20th century is the Olmsted case involving wiretapping. And I'll just tell you what Brandeis did there, and then I'll try to channel him and imagine what he would say about warrantless metadata collection. So Olmsted is prohibition, and it's the war on booze, and the police suspect some guy of bootlegging and making telephone calls to Canada to arrange for the importation of delicious but illegal cocktails. And they tap his phone, and they do so by putting taps on the wires under the sidewalks leading up to his office. And they listen in on his phone conversations and conclude that he's wildly bootlegging, and they indict and convict him. He objects. There was no warrant to seize my telephone conversations, and therefore the conversation should be excluded as a violation of the Fourth Amendment. In a wooden and formalistic opinion, a majority of the court, led by Chief Justice William Howard Taft, rejects the claim, no trespass, no violation. Invoking language similar to that of Justice Scalia in the Jones GPS case, Taft said the framers intended there to be physical trespass into the home before the protections of the Fourth Amendment were triggered. Here, the police were on public property when they put the wires on the taps on the wires in the sidewalk leading up to his office. Therefore, he's out of luck. Brandeis writes a visionary dissenting opinion. He first, like Roberts in the cell phone case, tells the story of the general warrants that sparked the American Revolution and describes how the king's agents would break into people's homes to read their private diaries in the search of the authors of anonymous pamphlets criticizing the king. Brandeis talked about the centrality of anonymous speech in a free society and said that political dissent was impossible unless our most private papers were immune from unwarranted and unregulated government snooping. And then Brandeis confronts the nub of the matter, which is that the framers imagined trespass as a protection for privacy, but here there was no trespass. And Brandeis had in his desk drawer a clipping from 1927 describing a new technology, namely television. And he wanted to make a reference to this technology, but he misunderstood it as a two-way communication. Basically, he anticipated Skype. And his law clerk, Henry Friendly, who later became a famous judge, said, this is too far out there, no one will believe it, just leave out the reference to television. So Brandeis didn't explicitly quote television, but he does have a passage where he alludes to it, and he says, ways may someday be developed by which it's possible, without physically intruding into the home, to extract papers from secret desk drawers and introduce them in court. He said a far smaller intrusion at the time of the framing was considered a violation of the basic rights of Englishmen. We need to translate the Fourth Amendment so it protects the same amount of privacy in the age of the wires as it did at the time of the framing. So that's just this gorgeous inspiration to the courts today to engage in similar acts of constitutional translation. This is not going to be, this is a sort of simplistic and clumsy attempt to channel Brandeis, but I think a Brandeisian judge might say the collection of metadata has the potential to destroy any degree of public anonymity and to reveal a great deal about our most intimate thoughts, expressions, and emotions. At the time of the framing, it was believed that public anonymity and control over our thoughts, sensations, and emotions was necessary under both the First and Fourth Amendment. Therefore, both amendments prohibit mass metadata collection today. That's about as good as I can do. Ed, why don't you try to better that?
All right, well, let me make my pitch. And so you'll see the difference between a lawyer's pitch and an engineer's pitch here. Jeff starts with the Constitution and argues down from there, if you will. I start with the facts on the ground and argue up from there.
Brandeis would have approved of that, by the way, as well.
Oh, excellent.
Good. Yes.
So first of all, as I described before, I'm skeptical of the idea that a lot of information can be collected and kept around for a long time without risk of misuse or abuse. And so I think although it's important to try to limit and regulate how information is used after it's collected legitimately, at the same time, you want to talk about the collection of information as a harm or a risk in itself. And so then the question is, does all of this information really need to be kept? Does it really need to be collected? And I think, first of all, that the case has not been made that this actually provides values. We saw this, for example, from the President's review panel, which, as Jeff said, concluded that they couldn't point to, and in classified discussions with the intelligence community, were not pointed to convincing cases where the collection of this information led to or stopped a terrorist attack. So I think the need for it has not been shown, number one. And number two, when you start to talk about the scenarios, even the hypotheticals about how the collection of this information might lead to disrupting a terrorist attack or identifying secret members of a conspiracy, when you start to dig into the details in those hypotheticals, what you see is that there are actually other ways to achieve the aims of the intelligence or law enforcement activities without collecting everything. By targeting the collection more narrowly, by starting with someone who is a legitimate target, getting information from them, and then you can think more narrowly about what you actually need. And you can be creative technologically. For example, you can do matching. If you want to know whether person A and person B are within 2 hops of each other, you can answer that question by asking, is there someone who has been in communication with both of them? And so that's a kind of query that you might do against data which is out there held by phone companies. You might be able to send a query out to the phone companies and say, oh, by the way, how many people are there? Is there a person who talked to both person A and person B? And if you start to see a lot of links between A and B, now you know that they're richly connected at the 2-hop level, even though you didn't ask for information about who that intermediary was. You didn't ask for information about a lot of people, just about the 2 who you suspected. So when you start to look at the specific cases, the specific things you'd like to do, and ask, how could that be implemented in a way that's involves less collection, less retention, and less aggressive use of information, in many cases there are answers, and there are better ways of doing these things. And I think that the intelligence community has just sort of backed into an approach of collect everything in case it might be useful, and not think really as systematically as they could about how they could minimize the collection and use of this information, so that they really only collect and analyze what they need in order to do the job that we as citizens have actually tasked them with doing.
That's great. So there's a pragmatic case against the collection, which could indeed have constitutional dimensions if you believe that the Fourth Amendment, or at least the First Amendment, impose some requirement that the least restrictive or intrusive means of collecting information be imposed. We'll do Q&A in a moment, and I want to take our vote at the end, but I think we have one other question to put on the table before we do that, and that is the collection of data of non-citizens abroad. So it's Section 702 of the Foreign Intelligence Surveillance Act that authorizes this collection. And although the intelligence agencies, I gather, have tacitly concluded what Ed just noted, which is that the domestic metadata collection may not be all that useful in preventing terrorism, they've taken a very different position when it comes to the collection of data abroad. Both the military and the CIA have claimed that the ability to seize all data in terrorist hotspots in Iraq, for example, has allowed them to single out, with individualized suspicion, dangerous suspected terrorists, and then to target them with drones or with focused attacks in ways that save the lives of American soldiers and have been effective in stopping terrorism. And the President's Review Commission noted or concluded that 702 collection of non-citizens abroad does have utility, unlike that of domestic citizens at home. I have to confess, I don't have a lot of details to add to the legal analysis on 702 because the courts have been so extremely deferential to the collection and analysis of the data of non-citizens. A case called Verdugo-Urquidez held that the Fourth Amendment actually doesn't apply to searches of non-citizens abroad, even when conducted by US agents. There were vigorous dissents by justices who insisted that the US government should be bound by the Fourth Amendment wherever it was operating, at home or abroad, but those arguments were rejected by a majority of the court. So audience members may be able to fill in more details about the best legal and statutory case against the collection of data abroad, but my sense is courts are much more deferential on that score. Let me turn it over to Ed to ask, why is it that this collection abroad is more useful? Is it in fact more useful, and could it be conducted in a less intrusive way?
Well, let me answer that by saying two things. One is that in some cases there's a difficulty in practice of telling which communications are of US persons and which are not. It's usually easy to tell whether a communication was captured at an overseas site, but whether one of the people communicating, or both, are Americans, and whether one or both of the people are actually physically located in the US at the time, maybe at the time of the communication, may be more difficult to tell, because US to US communications do sometimes get routed through other countries. The internet works in mysterious ways. And so there is this practical problem separating foreign from domestic. And that's at least one reason why, why we should be thinking about the status of apparently foreign communications, because they might not be actually foreign. So that's, I think, the first thing I would say. As to the question of why something like metadata analysis might be useful overseas, and particularly in conflict areas, more so than in the US. I have to get a little technical, but I think I can give the idea. So one of the things that you might want to do in analyzing this data is to build what machine learning people call a classifier. So you can think of a classifier as some kind of rule that is inferred from a big data set that separates things into two categories. And let's say the categories might be, this person is probably an insurgent, this person is probably not an insurgent. Let's say in a conflict zone. And so the way this works is you have data for a large number of people, and for some of those people, you know the truth, or you have confidence, or with reasonable confidence, you know some of these people are insurgents, some of these people are not. But in general, as an abstract matter, the classification is just a matter of taking data about a large number of individuals. For some of those individuals, you know which of the two categories they fall into, and then you analyze that, you infer a rule, which you can then use for dividing the unknown people into which category they're likely in. Now, for a method like this to work, it turns out that you need to have a lot of examples of people who are in category A, and a lot of examples of people who are in category B. And so that might be the case in, let's say, a conflict zone. You want to know whether someone is likely a combatant or not. If there are a lot of combatants and there are a lot of non-combatants, and you have good data about that, maybe you can build a model that's actually fairly accurate. But if you're trying to, say, do an analysis over the US population and you want to ask who's secretly a terrorist and who's not, you just don't have a lot of examples of people who you know are secretly terrorists to use to feed into that model. And so the analysis is not likely to work. And so for technical reasons like this, there's reasons to believe that in certain kinds of overseas settings, you're more likely to be able to use an analysis. One other thing I would say is that one of the uses of this kind of analysis is to detect people who are doing using certain kinds of countermeasures against being tracked. For example, a person who throws away their phone and gets a new one. They get a new burner phone or a new phone that is not easily connectable to them. And so then you might ask, okay, we've been following this person around by monitoring their phone, and then on date X, suddenly that phone disappears out of our data. We think the person has a new phone, but which of the phones that came online at about that time is the one that they were using? And so now you're going to look for another phone that has calling patterns very much like the one they used before. So in an environment where a lot of people are using that kind of method to try to evade being tracked by let's say, US forces, then you might be able to solve or counteract a particular bit of tradecraft that an adversary is using, if they're using it at a large volume. And so it may be that the benefits of overseas use are something like that. Whereas in the US, there are not so many US citizens who switch to surreptitious phones in order to evade in order to evade an intelligence agency tracking them. And so the value of trying to track these things down may be less.
That's very helpful. So you both told us that if there's to be a legal case against this for collection abroad, it's likely to turn on the fact that it's inadvertently sweeping up lots of data of US citizens, and you've also explained to us why it might be more effective. It's worth noting, of course, that our European friends and allies very much and strongly reject the crisp line we draw between citizens and non-citizens. It offends their universalistic sense that all human beings should be entitled to the same basic rights of privacy, setting aside the diplomatic trouble that we've gotten into with the surveillance of Angela Merkel and other foreign leaders. This legal line, so important in US courts, may cause us grave diplomatic trouble down the line. So we've tried to present to you some of the issues, and let's have a discussion about this, and then we'll take our vote at the end. Yes, sir.
I guess, could we ask people to come down to the microphones and to ask so that others can hear? All right, well, maybe in your case, we don't need it.
Sorry, I got allergies.
Yeah.
Okay, I'm kind of mixed between both of you. As a government employee and I'm in law enforcement, I want as much information on the bad guys as I can get forever. I want it all. As a citizen, as an American Muslim, as a black person, as a grandfather of Hispanic children, I want privacy. I don't want to be snatched up at the middle of the night and, taken away, and then later I got to prove that I didn't do whatever. So I don't know which side to go with. But I do have a question of you. What happens to somebody in a foreign land that's a dual citizen of 2 countries, or sometimes 3 countries? How do we handle that? Not check the American?
What a great question. There's a right answer, and my instinct is if you're an American citizen and you also have dual citizenship, you count as a US citizen, unless anyone wants to dispute that. I think that US citizenship is a really great thing to have from a legal perspective, and it's remarkable how firmly our constitutional tradition has drawn this line. In the 14th Amendment itself, the crown jewel of American equality, passed after the Civil War, the framers firmly distinguished between the privileges or immunities of American citizens, which they believed included most of the first 10 Amendment of the Bill of Rights, and the basic rights of all persons, citizens and non-citizens alike, which were limited to equal protection of the law and due process of law. And you even see heroic defenders of free speech and equality like John Marshall Harlan during the Gilded Age as a sort of open nativist saying things about Asian immigrants that appall us today. He and Lincoln and other Republicans of that era saw no contradiction between firmly defending the rights of citizens and questioning the rights of non-citizens. It's just a quirk, it's a reality of American constitutional history, and it's a good thing to be a citizen. I think you gave a beautiful statement of the tensions between the topic that we're talking about here. And one thing that I learned so much about from Ed is that you don't always have to choose between privacy and security. He's telling us that in some cases the surveillance doesn't work, so it's really not worth surrendering liberty. But in cases where it does work, it can often be designed in ways that protects privacy and security at the same time. So maybe ultimately there are some silver bullets and you may not have to choose, but thanks for framing it that way.
So it really is, I think in my mind, very much about the ability to target the surveillance and the analysis at the places where it really is justified by legitimate law enforcement and legitimate intelligence activities, and trying to limit the extent to which you broaden that unnecessarily. There's one more thing actually about this issue of the treatment of non-US persons, which I think should be on the table. And that is that current policies in this respect are really bad for business. And what I mean by that is this, that the combination of US companies wanting to sell technology to overseas customers and the lack of protection for those overseas customers under US law, and the ability of the US government to compel US companies to turn over data and perhaps even to create backdoors in their products, that makes overseas customers quite nervous about buying US products. And so one of the big sources of pushback in Washington about these issues, besides civil liberties and besides the other concerns, has simply been from business interests in the technology industry. And I think, although it's easy, maybe a little too easy for us here in the ivory tower to just shrug that off and say, well, that's just somebody trying to make money, which certainly is true, and I'm not going to say there's anything wrong with that. We should also recognize that a world in which each country has its own domestic internet, each country has its own domestic technologies, and they don't play well together is not a world we want to live in, even leaving aside the interests of our domestic businesses.
More questions? Good. Please come down.
First, as a historical matter, by the time Louis Brandeis was on the court, which is when the ACLU was founded, he gave up all of his outside interests except for Zionism and outsourced them to Felix Frankfurter. But as a U.S. citizen living abroad, I've been told by various scholars that my conversations with Americans over the international cell phone or whatever get tracked as well, and there's no ready-made way of distinguishing between U.S. persons abroad and non-U.S. persons abroad. The question is, have there been any rulings or any legal action in other countries, in Canada, in Europe, that address these very same questions?
What a good question, and how sorry I am not to be able to answer it. Ed, do you know of any major litigation abroad? Great Britain?
There's also been litigation now being explored in Ireland, and with the recent revelations in Israel around the NSA surveillance that's being shared with Israeli intelligence officials. The only other point I would punctuate, I'm Anthony Romero, I've worked at the ACLU, I'm the director. The things that are especially challenging for our point of view also have to do with attorney-client conversations.
The microphone, please.
Oh, yeah. It's wonderful that Anthony is here and well worth hearing his insights.
The things that are especially vexing for our work also have to do with attorney-client conversations. And Ed, I was just wondering, and thank you for being an expert in some of our litigation, and your affidavits are brilliant, and it's always good to see you, Jeffrey. How would we approach this from a technological point of view? We have now adapted to a new normal, where if we have to talk with the family members of our clients, we are very careful. Certainly, we don't use the phone, we don't use the internet. Even if you leave aside the fact that before all of these revelations, we had once given some credence to the idea of attorney-client conversations being privileged and not open to easy surveillance. And we always had the hubris, or I had the hubris at least, that no one would dare ask for a wiretap on the ACLU and his clients, or his or her clients. We don't feel that way anymore. Now everything that we really have to do that is very sensitive, we fly and talk in person. Every case, whether it's Mr. Alaki's family, whether it's Khalid Sheikh Mohammed's family, whether it's the family of even Ed Snowden, whom I've met, and we talk with his family on his case. So can you talk a little bit about how technologically could you carve out or minimize for the attorney-client conversation being breached? And one of the stories, which I know that you both know, that there was I think it was the Washington Post leaked a story about how the NSA had collected data on the client conversations between the government of Indonesia and a Washington-based law firm, and had turned over the content of those communications from the law firm and the government of Indonesia to the Commerce Department, so that the US government would have the benefit of the insights of those attorney-client conversations in trade negotiations with the government of Indonesia. The private bar has been virtually silent on this issue. So it's not just international tech companies which are threatened by this. International law will wither on the vine unless international lawyers can be assured that their communications are not also intercepted. So Ed, I would just love your thoughts about that issue. And then secondly, is there a way to fix the standing phenomenon from a more than vexing? When we were up before the court in our Clapper case, when we were thrown out because we could not prove that we had standing to challenge the statute, the FISA Amendments Act, and the NSA surveillance program. And the very first document that Ed Snowden released gave us standing, the very first one, that Friday afternoon, and it was not coincidence. He handpicked that one document, and the first thing he said to me when I walked into the place where I met him in Moscow was, "You got standing now, don't you?" Right? And he fixed a problem that the courts put almost an impenetrable barrier to us. And in Fourth Amendment law, for those who practice it, I don't know this as well, my boss, Susan Herman, does, there is a practice where if the prosecutor knows of exculpatory evidence that the defense should be aware of, there is an obligation that shifts that burden from the prosecutor to the defense. So in a case where a group like the ACLU brings forward a bona fide case on surveillance, could we imagine a technological fix or even a legal fix that would then shift the burden of proof from the government, knowing that we do indeed have standing and that our clients did indeed were the subject of the surveillance, to shift it then to provide that evidence that could allow the case to go forward? It would require a whole different doctrinal shift, a whole development in the law, but it's useful to think about the paradigms in the criminal law context that could be used, and I'd just be interested in your thoughts on it, Professor.
Sure. All right. Let me take those questions in reverse order. Okay. The question about standing, right? And the issue there is, can you establish that your information was actually captured, right? When the government is not saying whose information was captured. And in one sense, the answer is simple. The government knows whether your information has been captured. They have built expensive databases where they can go and type in a phone number and get all the information they have about that phone number. And so an analyst could very easily just go to that database, put in your number or numbers of your people, and they would know. And of course, the legal problem is you can't force them to do that. And in the absence of evidence that you're in that database, you don't get standing. So to me, that's not really a technical problem. It's really a legal problem, that the government can hide the information about who has standing and therefore create a situation where nobody can sue, even though we know information of a lot of people is being captured. And it's only that bit of good fortune that a document that showed that you in particular were under surveillance was available, that let you break that catch-22. Beyond that, I don't think there's much you can do technically. Now, of course, government could build some sort of facility which you could query with your phone number and find out if they have anything on you. That could be automated if they wanted to do it, which of course they don't. As to the question of how you can have a really secure conversation against a really determined and powerful and technically capable adversary, that's really hard. Certainly, doing it in person is valuable. It's a useful method, but you still need to worry about whether there is some surveillance device present. And the world's greatest surveillance device, of course, is one of these. If you had asked a spy of the 20th century to describe the perfect surveillance device, the surveillance device of their dreams, they would say, well, it's got a microphone on it and a big battery, it's got a lot of storage, maybe a radio so it can send the data off, and ideally we'd have some way of recharging that battery. We'd like it to look like a thing that the subject has around them all the time. And this is really too much to ask for, but we'd like them to carry it with them wherever they go. So you have to get rid of this or put it in a metal box. Take the battery out. It's not even enough to turn it off against a really sophisticated adversary. And then talk in person in a place where there's not a device around that has a microphone that can hear, if you want to go to that length. If you want to communicate electronically, there are specialized tools available. And I know you have technologists who know about this. Like Tor, you could use Tails, for example, for a secure email or chat. And those work well if you use them with extreme discipline. There are many mistakes you can make, things you can do wrong that slip up and end up leaking information or letting an intruder in. So that's difficult to do. There's no substitute for an air gap for having when you need to store. I mean, another issue is how you store information securely. And there's no substitute for having a device that doesn't have a network, that doesn't have a radio, and that's well locked up, along with use of encryption. This is very difficult. And really, if you are a high priority target for a very capable intelligence agency, the fact is that you can make them work hard, but you probably can't keep them from knowing what they want to know. But even that is not nothing for an outfit like the ACLU, because there are reasons, policy reasons and legal reasons why the government doesn't want to be too aggressive in getting information specifically from you. And by protecting things as well as you can raise the bar for them and make them really target you in a conspicuous way, or a way that might be risky for them in order to get information. That's the best you can do.
And this will be the last question.
Okay, so So originally when all the stories broke out, we found out that the Congress really didn't know that much about what was actually happening with the data collection, the metadata and all that. There's Keith Alexander famously lying before Congress saying that we didn't collect all this information. So should Congress, so how much, slower? Oh, sorry, okay, yeah, sorry, I'm speaking too fast, I guess. So when all the data, the Edward Snowden stuff first broke out, we realized that Congress really didn't know all that much about metadata. There was Keith Alexander famously lying before Congress about them not really collecting all this data on Americans. How much should Congress know about the metadata? How can we as citizens be fully informed about all this programming and all these programs? And how can we ensure that Congress is fully informed when we're making our decisions?
It's a great question. One of the least defensible stances of the administration early on was that the details of the programs had to be concealed, and also the legal opinions upholding them had to be concealed. And it was only under pressure from Congress and elsewhere that it finally released the drone memos, the secret FISA opinions upholding the programs, even the legal arguments that had been advanced to uphold them. So that kind of transparency, which can't possibly endanger any kind of security, is necessary. There were situations where senators like Wyden and Durbin and others complained that they had been briefed but weren't allowed to talk about it, and said if Americans knew just how bad things were, they would be shocked. Hopefully that's happened a bit too. But I think that one of the virtues of the Snowden revelations has been to make it harder for the administration to refuse to brief Congress, because its main defense after the Snowden stuff broke is, hey, Congress, you knew about all this and bought into it as a result. So political pressure, formal requirements of briefing are necessary, but you're absolutely right that oversight is impossible without that kind of information sharing.
One of the problems that often happens with oversight in this area, whether it's Congress or the White House or other entities, is that a member of the Intelligence Committee might be entitled to ask questions. They ask questions, and they get an answer that's true, but not truthful, but not enlightening.
Truthiness.
Well, it's maybe true in a formal sense, not truthy meaning sounding good, but actually true, but just not enlightening. It doesn't really get to what they were trying to ask with their question. And it's especially easy for intelligence agencies to do that with respect to some of the programs that are somewhat technical in nature. When the answer is technical, it can be, and you are describing technical information to a person who is less technically sophisticated, it can be very easy to hide the ball and tell them something that's true, but doesn't let them really understand the significance of what was said. And I think one of the big problems with oversight in this space is exactly this, that the overseers are often not in a position to understand technical information when it's given. They're not in a position to ask follow-up questions about it, or simply to say, that just doesn't sound right. And they have not had much access to technical expertise in this space, partly because the information is often so closely held, highly classified, that they're simply not allowed to bring many people to the meeting. And among the people who get left behind are the people who are able to challenge the technical assertions of the intelligence agencies.
Okay, so it's time for our vote. This double Charlie Rose format has been an experiment, but I hope you've enjoyed it as much as we have. And the question on the table is, do you believe that indiscriminate collection of the cell phone data of... What? Sorry? Oh, you're saying that it's going to be an overwhelming rout. Well, here's my caution to you. Both as head of the National Constitution Center and as a proud civil libertarian, I'm not asking you to vote your policy views. I assume that many people in this room think that this mass data collection is a bad idea, and Ed has told us why it doesn't work. But that is not the question. This is a constitutional vote, not a policy vote. And I described to you the fact that there actually are decent arguments on both sides of the constitutional question, at least according to current case law. So let me make it a little bit sharper by saying you're not the Supreme Court. You're basically a judge applying the law as you now understand it, so beautifully, because we've explained it so fairly. And the question is, do you believe that unregulated collection of the cell phone data, of the cell phone metadata of US citizens violates the Fourth Amendment as currently construed by the courts? Who believes that the unregulated collection does not violate the Fourth Amendment?
Got some?
And who believes that it does violate the Fourth Amendment? All right, about 2/3 to 1/3, a fine and balanced constitutional debate. Thank you for a great conversation.
That's great. Thank you.